Yeah, what are we talking about today, Steph?
All right, so I'd like to welcome everyone and thank you for joining for today's presentation. My name is Stephanie and I'm an articling student at Russell Alexander Collaborative Family Lawyers. So I'm just going to start by giving some introductions and letting everyone know what's on the agenda for today. So you will notice that the chat box has been disabled to ensure attendees remain anonymous, but we do have the Q&A box feature. So if you do have any questions, please submit them through the Q&A. Also, please keep in mind that this presentation is intended to provide general information on the topic of divorce and property sharing and should not be considered as legal advice. So in this 1 hour presentation, our panelists will be discussing the following
We're going to
topics.
cover all this in 1 hour. Oh my God, we got to get
I know.
started.
I hope you have some caffeine in your systems, you guys. So we're going to go over the basics, going over calculating and sharing family property, the home, special considerations, onus, equalization, and limitation periods. As I mentioned, we have that Q&A box available, so there will be a Q&A segment at the end of the presentation. So if you haven't already, please feel free to submit your questions through that box, and we'll do our best to get to your question either during the presentation or at the end. We will be providing helpful links to any resources mentioned through the presentation in a follow-up email, so keep your eye out for that. And just a quick note to those of you in the legal community, this program has been accredited by the Law Society of Ontario, so it contains 1 hour of professionalism content. So with all of that information out there, it's now my pleasure to introduce our panelists for today. So we have Bill Rogers. He is a managing associate lawyer at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he has also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014. So that was the decision in McConnell and Huxtable. So that prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. So when he's not practicing law, he loves spending time playing music with his band Soul Custody, soon to be renamed to Soul Decision-Making Authority.
Parenting
And
time.
parenting time. So Rick is an associate lawyer and brings over 14 years of family law expertise. Rick focuses on all aspects of family law and matrimonial law by supporting his clients in resolving matters. He fosters strong relationships with his clients that are built on trust and transparency. Rick collaboratively works with his clients in achieving effective solutions through various dispute resolution mechanisms, such as finalizing domestic contracts through negotiation, mediation, and collaborative law process, or through litigation if necessary. And last but not least, Russell Alexander is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell uses his knowledge and expertise in collaborative family law with a client-focused approach by creating unique solutions for each of his clients. So now that you know a little bit more about our team and what we have on the agenda for today, I'm going to pass things over to Russ to start the presentation and introduce our little teaser.
Yeah, and we have extensive show notes. So we're going to give you all the links, all the cases at the end. I think, Steph, you should give a special acknowledgement to the law students who help you put those together.
Yes, they did a phenomenal job. We're so lucky to have them. So that's Joseph and Shanza. Shout out to them.
Thank you so much. All right, so this is our latest ebook, Mediation and Family Dispute Resolution. We're at the end of this program. Steph's going to tell you how you can get a free copy of this. But let's make a start. Let's throw the poll question up first. Everybody, please put the Q&A into the Q&A box. And the feedback we've gotten on the polls is makes it much more interactive. So just please take a minute. We'll give you about 30 seconds or a minute to answer the poll questions. We appreciate everybody's feedback. And Steph, the people who've been watching these programs before are probably getting sick of this, but are you able to offer a special guarantee today?
Of course, like always, we offer our full money back guarantee on today's free webinar. So if you do want to take advantage of that, please just let us know.
How can you go wrong, right?
You can never go wrong with that.
We're going to get everybody out as soon as lunchtime's over. Let's see who we have joining us today. Thank you, everybody who submitted your votes. So our audience consists of legal professionals, 45%, professional in another field, 22%, currently going through a separation and divorce. Well, you're going to learn a lot here today, 23%, helping a loved one and other, and we're going to find out who the others are. So thank you, staff, for those very kind words. I think Bill's going to take us to the year 1215 and the Magna Carta and tell us about the basics. Over to you, Bill.
Well, I'm not going to go as far back as that today, although trust law is from about 1,000 years ago in England. It's true, but I'm going to talk about first, what is property? How is property defined? And the Family Law Act, Section 4 definitions define property as any interest present or future, vested or contingent in real or personal property. So the interesting point there, present or future, there is a spot on the financial statement saying money owed to you. That's property. It's a future interest, for example. Real or personal property, we all know what real estate is. It's land, and then
dirt,
everything else is personal. Sorry?
Real estate's the dirt, right?
It is. It's actual dirt. And I think that's why they call it real estate, because unlike a bank account, it can't disappear. It's actual piece of earth. You can grab it, put a fence around it. So they call it real. And personal property is everything else. Money in the bank is property. Stocks and bonds are property. Pension is considered property. And I like to look at it as make a distinction between property and income. Income is a separate thing, and it ties into spousal support and child support. So it's treated separately. Now, what is financial disclosure? Basically, if you're, I always tell my clients, you be 110% honest with your financial disclosure and everything else. Because if you're not, the judge will find out eventually. May not be right away. When they do, it'll really hurt you. So just be honest about everything. And then you have to back up everything you say with a document, whether it's a bank record or a mortgage statement, that kind of stuff. The Supreme Court of Canada, in a case called Leskin, in 2006, quoted an earlier BC decision and said the following, quote, "Non-disclosure is the cancer of matrimonial property litigation." So I always tell my clients, be honest, you got nothing to hide. What documents do you need to gather if you're in court? Or even if you're not in court, you need these, basically your full tax returns from the last 3 years at least. Also your notices of assessment. Both of those are available online. More than once I've told a client how to apply to get on that website of the CRA, and usually they can, but you know, it's all there. It's very convenient. You also need most recent pay stub, and you're also going to need to back up all your assets that you say you have with some kind of document. So it's going to be bank records, mortgage records, credit card statements. Sometimes you're asked to go back a long time, and the bank will say, well, we can only go back so long, and then you have to go to the bank and beg them, and it's quite a thing. But you try your best to get, your bank records from the date of marriage in 1979. Could be a little tough to get, but theoretically you're supposed to. And a financial statement is where you put all this stuff. It's a sworn statement. It's made under oath. So if you lie, you're actually committing perjury. So always be 110% honest. Believe me, it's the way to go. And every number on your financial statement, again, has to be backed up by some kind of document, bank record or credit card record, whatever. On a financial statement for married people, there's usually, there's three time snapshots: date of marriage, date of separation, and today. So you have it's a lot of information to gather, but it's one of those things you just have to do. And again, the more honest you can be, well, you have to be honest, it will pay off, and never try to hide anything.
And there's two financial statements, right? This is the 13.1, and then there's the 13. What's the distinction, Bill?
Yeah, one of them has property on it. If you're married, then you use the 13.1, which talks about your property. If you're not married, then you just use the 13, I think it is. It's just about income, I think. Yeah, there's that too.
Okay, a couple questions real quick, Bill. These are just coming in from the audience. Is income owed to you property?
Yes, it is. Any future interest? Yeah, there's a spot for it. Money owed to you, and that goes on. That's your property.
Including if that's income, I guess?
Well, it's property.
Yeah, okay.
Yeah, it's considered property.
One question that came in ahead of time. What happens in a case where one of the parties kept all the assets in his mother's name and is also working under the table and not showing real income? So in terms of the property side, what's your answer to that question?
Well, on the property side, putting all your assets in your mom's name is some people do it. It usually doesn't work. And one way of counteracting that is to make a trust claim. And you basically say, well, yeah, our house is in your mom's name, but really I deserve part of it. So she's holding it in trust for us. That's your trust claim.
And we have a separate live event to talk about that. Also, we'll do an advanced version of this where we'll talk about crypto, non-fungible tokens or digital assets as well. But again, this is the one-on-one version. We're giving everybody a quick overview. So thank you for that, Bill. All right, Rick. So calculating and sharing property, what do we want to look at here? And sorry, our notes are going to be provided at the end. We had another question looking for supporting materials. So you'll get that in a follow-up email. Thank you, Rick. Sorry, you're up.
Well, thanks, Russ. Thanks, Bill. So calculating and sharing family property. So the question is, what is property? The Family Law Act has a certain term or terminology, specifically the term of net family property. What does that mean? What's the intention of the net family property scheme under the Family Law Act? So on review of the case law, specifically a case called Cosentino back in 2015, ONSC 271. The court there says that the general intention of the net family property equalization scheme of the Family Law Act is that each spouse will share equally in the monetary product of the marriage. And the meaning of property in net family property must be interpreted in according with this general intent. So clearly, when the legislators sat down to put the Family Law Act in place, the intention was right from the beginning. The purpose was to share everything equally, and that's how they approach this. In terms of the calculation of the net family property, again, it's set out in the Acts, sections 4 and 5 specifically. First, you have to determine what the net family property is of each spouse. And that's basically by determining the value of the property owned by them and including any deductions or exemptions or exclusions. And then once that's done, then you would have to do an equalization calculation. And again, the same case of Cosentino says that pursuant to the stage 1, section 4 requires identification of all relevant property and the ownership of that property. Ownership includes registered ownership and consideration of trust principles. Then the court must determine the relevant deductions and exclusions under sections 4.1 and 4.2. Once that's been done, at that point there, then the calculation of each spouse's NFP is determined, and then from there, the equalization calculation can.
Can you tell us what just for the audience members who don't know, Rick, what's an NFP?
So NFP is the abbreviation of net family property.
Right, and the chart that gives us all the assets, right?
That's correct, yeah.
Yeah.
And we'll be covering that a little later in the slides, I believe, but that's the abbreviation of it. To do an equalization calculation, as Bill said, that you have to look at date of marriage assets and date of separation. Date of marriage assets is effectively property owned and brought into the marriage by both spouses, and that property can be held solely in that person's name or jointly with someone else. probably for most family law lawyers is the most common problem is lengthy marriages. So if a marriage is 30 years old, most spouses aren't contemplating 30 years prior that they're going to end up getting a separation or divorce. So they're not usually holding on to the supporting documentation. So it's going to be difficult to prove an asset walking into the marriage if you don't have that documentation. Date of marriage property is excluded from the division, and we'll cover how the equalization calculation is going to be done a little later in the slide show. Moving on to data separation assets, that's effectively assets owned on the date of separation. And again, the asset's going to be held solely in one person's name or in conjunction or jointly with someone else. And again, that has to be proven, as Bill said, that you have to prove your
Couple quick points, Rick. This is really good. When you say equalization, that's just a fancy way of saying sharing, right?
That's right. That's right.
And data separation is important because the statute says that's the valuation date that we value the assets. Is that right?
That's correct.
Okay.
Yeah. Moving on to the concept of deductions. So deductions are often referred to as date of marriage credits or premarital quote unquote deductions. And these are excluded from the division. So the idea is, from the way the Family Law Act is designed, that spouses, married spouses, are on separation, are sharing equally the fruit of their marriage from the date of marriage to the date of separation. Okay. And so the value of property being brought into the marriage, if it cannot be ascertained, is excluded. It's deducted from the overall calculation. As Bill said, the onus is on the person. The legislation requires that the person supporting a value, whether on date of marriage or date of separation, is supported by documentary evidence. And in the case of Townsend, the court in that case reaffirmed that principle to say that the trend in case law is that the claim should be supported by documentary evidence. The legislature places the onus of proving the deduction from net family property on the person claiming it. Okay. Section 4.2 of the Family Law Act is a section that deals with what's called excluded property for purpose of determining and sharing family property. And it lists a series of items, 6 items there that are excluded that do not fall in a person's net family property calculation. And those include property other than a matrimonial home that was acquired by gift or inheritance from a third person after the date of marriage, income from property from either a gift or inheritance that was received from a third person after the date of marriage. Specifically in the case of an inheritance, if the donor or testator has expressly stated that it to be excluded from a spouse's net family property. Oftentimes, if you'll see in wills that there's a provision in the will that sets that out, that the testator will say that any income that's derived from any property that's going to be bequeathed to be excluded. So sometimes you'll find that language in wills. Third is damages or right to damages for personal injuries, nervous shock, mental distress, or loss of guidance, care, and companionship, or part of a settlement that represents those damages. 4 is proceeds or rights to proceeds of a policy or life insurance. 5 is property other than a matrimonial home into which property referred to in paragraphs 1 to 4 can be traced. And then 6 is properties that spouses have agreed by a domestic contract not to be included. So it's possible, and you'll often find this in cohabitation agreements, where people exclude property in general or certain types of property from ever being equalized. And lastly, unadjusted pensionable earnings under the Canada Pension Plan. So these list of enumerated exclusions. And again, though, the premise again is it seems to focus initially on that purpose or intent that I spoke about initially. These items generally don't arise out of the monetary fruits of the marriage on separation. They're usually outside sources. Most commonly, I guess for lawyers, we'll see the concepts of either gifts, monetary gifts, or inheritance. And generally, the case law states the following legal principles: that a property that may otherwise be excluded, but can be traced to property used for common purposes of the family, cannot be excluded from the net family property statement. So, for example, if there was a monetary gift given, and some of that money was spent, if there's still a balance owing, you can claim the balance owing on the separation if it's still existing on that date, but you can't claim the full amount if it was already used for common family purposes. And one example of this is a case called Maharaj and Wilfred Jacob. The wife's parents gave the wife $25,000 in 2010 when they sold their home. The money was deposited into the joint account. And in February of 2011, the wife asked for the $25,000 back. She spent some of that money of the $25,000. At the time of separation, only $10,000 of those funds were in a GIC. She sought to exclude the $10,000 from her NFP. And the husband argued that it was placed into a joint account and shouldn't be excluded. So the court in Maharaj basically said this: there's no doubt that the $25,000 was placed into a joint account. And they reaffirmed the principle that where property, which is otherwise excluded, is commingled with property used for common purposes of the family, it cannot be excluded. However, where a joint account is merely a conduit for money to flow from one person to another, or when money is parked in a joint account, there is no commingling. So the court found that I find that the $25,000 was not commingled. It was quote unquote parked in the joint account for safekeeping. Ms. Maharaj asked for it back, and the husband gave it back. Therefore, he recognized it was her money, and now he cannot say that it was commingled and should not be excluded. So she was entitled to the $10,000 exclusion ultimately for purposes of equalization. Another interesting point is a case called Townshend and Townshend. In this case here, that Mr. Townshend received $25,000 from his mother as a gift in June 2001. And those funds were placed into a joint account. The court in that case did not allow the $25,000 from being excluded. At the trial level, and I'll get to there's a court of appeal. It was appealed at the court of appeal, but the trial judge basically said that by the nature of the transfer, it loses its exclusionary transfer. It was appealed to the court of appeal, and the court of appeal reversed that, and they basically said that the husband was entitled to exclusion of 1/2 of the amount of the gift that was given to him from his mother, even though it was deposited in the joint account. The excluded property deposited in the joint account only loses exclusionary character to the extent of 1/2 of the interest, and the other half of the interest, or the other 50%, was presumed to be gifted to the spouse.
There's a lot to unpack there, Rick.
There is.
Thank you for that. And we've got case examples of all these studies. So one point I would make is personal injury awards may not necessarily always be excluded. There's some case law that says certain aspects of those awards can be treated as property. Question came in about post-separation assets. Those are not generally considered property. Is that correct, Rick?
That's correct, though. So really the two pillars are from the date of marriage, the date of separation, for purpose of an equalization.
I really like this question that came in. Maybe you want to take a stab at this, Bill. Pre-marriage assets, can they be brought into the sharing of family property? What do you think?
Well, as Rick said, normally everything you have on the day you get married, you keep.
But if they're cohabitating,
Oh, if they're not married?
yeah, and they get married. So
Right.
those cohabitation marital assets, what do we do about that?
Well, normally, in terms of equalization, everything you have on date of marriage, you keep.
Right.
It doesn't go into your net family property.
Yeah.
So what you would do is, if there are pre-marriage assets that only one person is on title, then you'd have to bring a trust claim for those, which you can do.
In addition to your family law regime.
Yes, you can.
for sharing property, you
Yep.
bring trust claims, and we have another live event on that, which Bill did a great summary
Yeah,
of.
you can do a trust claim on pre-marriage and post-separation, and then equalization as well. So you have three things on the go.
It's just like a menu at a restaurant, right? I got the pre-marriage trust claims. Let's run our poll, and I got one more question while I've got you on the hot seat here, Rick. This came in advance, so thank you. Everybody keep having the questions come in. My ex has a business that he incorporated, an insurance adjuster. Is this still considered part of his assets when we're doing this calculation?
So,
The spouse is a corporation. Is that part of the marital assets?
well, a business corporation may have a value to it, and if it does, then it does fall in the concept of property to be equalized. So
Right.
the answer is yes.
The interesting thing on that though, Rick, is some people have I had a guy who had his business he was a motivational speaker, and he was the company. It was just him, and it was a company, but it wasn't really worth, like he couldn't sell it. It wasn't worth anything because it was just him. So you need to get these companies valued, and sometimes they have no value.
But now you can speak about sharing property, right? Motivation.
Absolutely. I'm going to sell you my corporation that is about public speaking, and I'm the only person who does any, and I'm not going to be in it after I sell it. So how much is it worth?
Right. And just another quick point about tracing, because this could be, kind of a difficult spot. Let's just say you get 50 grand inheritance cash. You go and buy your car, and on your date of separation, the car that you bought with that inheritance is worth 30. But you have a fairly clean trace there, but you're not going to get the 50, you're going to get the 30. And just with commingling funds, in the case you talked about it, both spouses were putting money into the account and paying household bills from that, that's been commingled, right? We can't distinguish which one was the inheritance or which one was the paycheck. So you want to keep an eye out for that.
And the trick is, Russ, like you said, if you have a gift or inheritance, do not commingle it. Keep it separate.
Yeah.
And your spouse will love you for that.
Yeah. Well, that's the advice we give, right? And the other, yeah, that's a great point, Bill. Thank you for sharing that. All right. So Bill was doing some late night research. Can you own more than one matrimonial home? Let's see what the results are. No, 25%. Yes, absolutely, 50%. Yes, but only if it's set cottage, 9%. If you're on title, 13. So kind of all across the map there. So let's get into this, Bill. Really important part of the family law regime for sharing property, this concept of a home or a matrimonial home. What are we talking about?
Well, yeah, you most certainly can have more than one matrimonial home. Typically, it's a house and a cottage. And the test is the cottage ordinarily occupied by the couple? So if you go up one weekend of summer, I don't know, that seems extraordinary to me. There has to be an ordinariness, a pattern. I mean, if there is, then yeah, you've got two matrimonial homes, the cottage and the house. I found a case where there was 3 matrimonial homes. It's a case called Bought and Bought, B-O-T. It's a 2010 case, Ontario Superior Court. 3 matrimonial homes, a house in Sudbury, a cottage in Whitefish, and a condo in Toronto. 3. And the highest one I found, Russ, and I was on Westlaw last night. I searched every case in Ontario.
I thought you were just joking when you said you're going to look it up, but wait, let's do a count. I'm going to say 6. What do you say, Rick?
I say, I don't know, 7 or 8.
All right.
4. I was hoping it would be higher. I wanted it to be like 50. That would be just really funny, but no, it was 4 matrimonial homes. So the case is called Bassam and Bassam, Bassam, 1982 Ontario case. Basically, they had 2 cottages in Ontario and 2 condos in Florida. And all 4 of them were found to be matrimonial homes. So 4 is the record.
What's special about the matrimonial home, though? Why do we care?
Well, because it matters if only one person is on title to it.
Right.
If it's a matrimonial home, then even though only one person owned it, it still gets split. It gets divided in the equalization. That's the big thing. Also, you can get exclusive possession of a matrimonial home, and it's section 24 of the Family Law Act talks about that. There's a bunch of stuff you can do. One of them is getting exclusive possession, so kicking your spouse out of it. Typically done in cases where there is domestic violence or a threat of domestic violence is usually the reason they do that. But again, you have to be married to get that relief. And do you want me to talk about what happens if you can change your matrimonial home halfway through the marriage or whatever? If it's not the home on date of separation.
Right.
Do you want me to talk about that?
Well, yeah, well, that's important because if it's no longer the home, then you get a deduction for a home that was a matrimonial home, but it lost that special meaning, right? It lost that special status.
That's right, because a matrimonial home must be ordinarily occupied at the date of separation. So if you have a matrimonial home at the first part of the marriage, and then you sell it and get a different one, the first one does not, it ceases to be a matrimonial home because it was not occupied on the date of separation. So you can get a deduction for that. And that's the Court of Appeal case. Everyone knows it's 1999. It's called Nahatchewitz, Nahatchewitz. It's common knowledge. It's just, yeah, you can do that and get a deduction. Change houses, basically.
Yeah. Tons of questions coming in. Thank you, everybody, for sending in your questions. One question was the date of separation defined. We've got a live event on that. Look for it. Basically, once one person makes a decision, then the relationship, and you have some kind of documentation or agreement to that effect. Pensions are part of property. Just on this issue of the home bill, if there's a matrimonial home and it sells, we had this question come in, it sells after the date of separation, right? You got date of separation value in today's market. A year later, that could be $300,000 more. What value do we use?
Well, that's the problem if you're using the matrimonial home law, which again is really, it's only relevant if one person's on title, and more nowadays, both people are on title, and then it kind of doesn't matter. Because you both have the same interest and it cancels itself out in the equalization calculation. But if only one person's on title and they separate, and then the house gets sold a year later for way more than it was worth on the date of separation, in terms of equalization, you're out of luck. What you'd have to do is bring in the trust claim.
You love these trust claims.
Trust claim, I'm telling you.
Why don't we just start off with trust claims and just forget about the Family Law Act, right?
Well, yeah, I mean, the thing is you can make trust claims even though you have equalization as well. But the case is called Rawlach. Everyone knows about that. So yeah, you'd have to make a trust claim saying, look, the date of separation value of the home is a lot lower than what my partner ended up getting for it. And by golly, I deserve some of that. I deserve some, so it's a trust claim. You can do it. People do it all the time.
And these provisions are super important. For a lot of families, the home is the biggest asset they have. So how we treat this home is significant. Let's run our poll. I've got a couple more quick questions for you, Bill, that came in. one just now. What about homes and properties in other countries? Is that subject to this sharing process we're talking about?
It is. Problem is, you can't have an Ontario court order the sale of a house in China or in France or anywhere outside of Ontario, really. But what you can do is ascertain the value of properties that are anywhere on earth, and you use those values in your equalization calculation. So that's what you have to do.
Yeah.
Try getting a real estate appraisal in China. I did that once. Whoa.
Or Spain.
Spain?
Yeah, we had a case in Spain.
Oh, did you?
But
It wasn't easy to get this stuff from China, let me tell you.
these questions are excellent. I want to thank our audience for sending them in. Keep them coming in. Last question, Bill, and then we're going to get to the results of our poll question. RV trailers, matrimonial home. Do the tires have to be on or off? What are we looking at?
Well, it depends on the state of the tires and how much they are inflated.
Okay.
Yeah, I mean, hey, if you're living in a trailer, it has a value. It's going to be a matrimonial home. Even if you don't own the land that it's sitting on, I guess it's still a home.
Subject to division.
Yeah, I think so.
It's an asset.
It certainly is.
I guess the real question is, does it attract the special characteristics of a matrimonial home?
I would imagine so.
Let's see what our audience thinks of this question. Are banked holidays or sick holidays considered property or income? Property subject to sharing, 18%. Income, possibly to spousal support, 31%. No, 28. Depends, 21. Other 2. So pretty widespread across the board here. What is the answer to this question? That is going to go to Rick in our next slide. Thank you, everybody.
Okay, well, banked holidays, they're considered property if they have a value on date of separation.
And they could be
Well,
significant, right? You know, like teachers, police officers, sometimes they have, you know, several months of banked holidays. It could be a fairly significant amount of money.
Yeah, usually this I found that this arises under collective agreements for unionized employees. So, but the question is, does it have any value? And if it's a future value that has to be realized and there's zero value of it on date of separation, then there's no value to it. I came across a case called Rickett and Rickett of 1990, and the husband had he was working with the Board of Education, and basically his employment contract stated that he was entitled to a sick leave or gratuity payment on retirement. But there were certain conditions that he had to meet. For example, he had to have 200 days of unused sick leave at the time. And if he satisfied that, he would be given a gratuity of a lesser of 50% of his annual salary, or $35,000. Again, this was a 1990 case. Wife tried to argue that the husband had 401 days of unused sick leave at the date of separation, but he was 10 years away from retiring, and at the time of the date of separation, that sick leave gratuity had no value. So that's effectively what the court said in that case. I know I jumped ahead on the list on special considerations. Pensions and survivor benefits, they're considered property for the equalization purposes. Pensions are usually are almost always included in the NFP, but they don't necessarily have to form part of the equalization. They can be divided at source as long as they're divided. Whether they fall into the equalization scheme or they're divided at source, they need to be accounted for. So oftentimes you'll find a scenario where if one spouse is able to pay off their equalization of the pension that they're owing to the other spouse, that would keep their pension intact for when they retire, and they would have met their equalization obligations. Survivor benefits, these are also they're considered an asset or property for purpose of equalization. There are certain criteria to satisfy it. Effectively, it depends on when the breakdown occurs and vis-a-vis the retirement. So, for example, if the relationship breaks down before retirement, then the former spouse is not entitled to any survivor benefits from the pension holding spouse. However, if the breakdown happens after retirement and that pension holding spouse is collecting their pension, then the other spouse is entitled to a survivor benefit. In a case called Withers and Withers of 2013, the court basically confirmed that a survivor benefit is a pension in its own right, representing an expected future stream of income that can be actuarially valued. So
these are significant assets. If you elect to do a survivor's benefit, and if you have an Ontario Power Corporation, I don't even know if that's called that anymore, pension, this could be a $300,000-$400,000 asset that goes on the spouse's side. They have to equalize it even though they don't get the money until the spouse dies. And many times it results in quite an unfair calculation in my experience. Has that been your experience, Rick?
Yeah. Most often you'll see it in older because of the requirement, Russ. They're usually older, and they're great divorces, as we say.
Right.
And that's the time when you find them, but it can cause some bizarre results, as you said. It covered the sick days and
if you win the lottery, hide the ticket and get a divorce.
That's right. Stock options.
Bill, you said you have to be honest in your disclosure. Come on.
Absolutely. I'm joking. Always be honest. Always, always, always.
Depends when you bought the lottery ticket. If it's post-separation, I think you're clear. But what if you bought it with jointly held funds?
Oh, the $2 that was from the joint bank account, Russ?
All right. Sorry, Rick.
That's
Keep going
right.
here. We want to get some Q&A at the end.
Stock options are assets and are to be valued. They can be. Again, though, there's a case called AE versus AE. It's a 2021 decision. And that case basically states that for purpose of support or property claims, they can be either property or income. And it depends on when the stock option is vested or not. Generally speaking, if the stock option has vested, it's considered to be a benefit that accrues to the spouse who receives them, and therefore it's to be included in their income. If on the date of separation, the stock option is unvested, then at that point it becomes a property for purposes of equalization. The court in that decision basically said that an unvested stock on the date of separation constitutes, quote unquote, a present right to acquire something in the future, and obviously usually with conditions attached. Stock options are very complicated. Usually you need a qualified business income valuator to value the options with full disclosure. Some of the potential problems with the stock options, there's a few of them, and again, it depends on the timing of exercising the option and its effect on the value. For example, a stock option may have a value on the date of separation. It may be a higher value, but years later when the trial comes, that option may have decreased. So there's a post-separation decline in value, and that may lead to some unfair results, and that needs to be considered. Notional disposition costs. Famous Court of Appeal decision, Sengmuller and Sengmuller of 1994. Effectively, the court said as a general, and I'm quoting this in another case from a Court of Appeal called Rakitova of 2016. And quoting their earlier cases, Sengmuller, the court there said as a general rule, in determining whether disposition costs should be deducted from an asset's value, the analysis should take into account evidence of the probable timing of the disposition. It's appropriate to deduct disposition costs from net family property, quote unquote, if there's satisfactory evidence of a likely disposition date, and if it's clear that such costs will be inevitable when the owner disposes of the assets or is deemed to have disposed of them.
Okay, Rick, hang on. You lost me at hello. What is a notional disposition cost?
So I was going to say that, Russ. Believe it or not, I just read your mind. So.
I think I know what it is, but for people who didn't spend, 7 years going to school, what does it mean?
Notional disposition costs are costs which would be inevitable when an asset is disposed of. So, for example, they could include a real estate commission, even on a buyout between two spouses. They don't necessarily need the real estate. There's no official sale, let's say, but they would attract what's called a notional disposition cost of the commission that will eventually happen when that property is sold in the future.
Right.
So you would allow that at that time when calculating your net family property.
Or your $500,000 pension, for example, is going to attract a 30% tax rate. So we reduce it by 150,000, if my math is right. And you use a smaller amount to share. So let's just flip over to our next poll. Thank you, Rick. That was excellent. Couple quick things. We have a question about unequal division. We're going to get to that. Tax-free savings account, our property. Rick, notional disposition costs, you can also apply them on the date of marriage assets. Lots of people don't think about that. Is that correct?
That's correct, yes. You can apply them both on date of marriage or on the date of separation.
And I know Bill and I were bantering about the lottery tickets. These can be very significant winnings. We have lottery cases on our blog. My analysis is it's going to be a fact-driven exercise in each case. So take a look at the case law, give you some guidance in terms of what we deal with lottery ticket winnings. But, you know, if you have a $1 million winning, people are going to fight about it, right? So take a look at the case law, understand if it's going to be excluded. All right, so this is another tough one for families, right? You know, you have these family cottages that have been in the family for 100 years. Should a family cottage owned in generations be excluded? You know, this creates a lot of inter-family conflict when a party gets separated and all of a sudden the cottage they've been going to for 50 years is gone or it's going to be sold. So let's see what our audience thinks. No, should not be. 34%. Depends how often you go to the cottage. It's a good answer. 35%. Depends how many generations the cottage has been in the family. 6%. Yes, it should be excluded. 24%. Clearly, lots of disagreement. Bill, what's the answer here? Family cottage. These are tough cases.
Yeah, they are. I mean, if you ordinarily occupy a family cottage, I mean, the law doesn't care if it's been in the family for 100 years. Bottom line.
Yeah, that's really where the rubber hits the road, though, right? That seems unfair.
Yeah, it's better to stay together than.
Bill, tell us about the onus. Who's got to prove
Yeah.
that? You know, it's a balance of probabilities, I assume.
The onus, well, the onus,
not just family cottages, but all these things
Yeah.
we've been talking about, exclusions, deductions.
In terms of an interesting thing is we're talking about if someone has a business or a corporation that's worth something, not the one-man operation who's a motivational speaker, because you can't sell that. But if it's a company that actually is worth something and you own it, you have the onus to get it valued by a professional business valuator. And that costs money, but you got to do it. If you're claiming any kind of a deduction or an exclusion from equalization, you have the onus to show that, for example, this was an inheritance and I kept it separate. It's up to you to show that. So yeah. But the big one I think is that people don't like is if they have a corporation that's worth something and they don't like the fact that they have to spend a lot of money getting it valued, but they do.
All right, thank you. Bring this home for us, Rick. We're going to talk about equalization. A couple of quick questions that are coming up. RSPs, I would think, would be considered property. This is kind of a really, do you ask teachers and police officers to provide a copy of their employment contracts? Well, you certainly want to learn about the sick days. So certainly more disclosure than less. But if you have an excluded asset and it increases in value, do you share the increase in value? I'd say no, it's excluded. Is that right?
Nope, that's what exclusion means. It's like it doesn't exist.
These are fantastic questions coming in. Thank you, everyone. Okay, equalization. Then we're going to get into some Q&A and a quick talk about the limitation period. Go ahead. Rick, you're up.
So the concept and purpose of equalization. So it's set out in black and white in the Family Law Act, specifically Section 5, Sub 7.
This is the fancy way of saying how you're going to share your property, right?
And it just basically says that the purpose of the section is to recognize that childcare, household management, and financial provision are joint responsibility of spouses, and that inherent in the marital relationship, there is an equal contribution, whether financial or otherwise, by the spouses to the assumption of these responsibilities, entitling each spouse to the equalization of net family properties, subject only to equitable considerations set out in subsection 6. And that's what we'll be talking about. Subsection 6 allows for an unequal division, and they list a list of factors. Effectively, basically, subsection reads that the court may award a spouse an amount that's more or less half the difference between the net family properties if the court is of the opinion that equalizing the net family properties would be, quote, unconscionable, having regard to, and it happens in cases where a spouse's failure to disclose debts or liabilities existing at the date of marriage, the fact that debts or liabilities claimed in reduction of a spouse's net family property, and if they were recklessly incurred or done in bad faith. Spouse's net family property consists of a gift made by the other spouse, a spouse's intentional or reckless depletion of his or her net family property, the fact that an amount of a spouse would otherwise receive under subsection 1, 2, or 3 is disproportionately large in relation to a cohabitation of less than 5 years, so effectively short-term marriages. The
2
fact that
years is unconscionable, 5 years and 1 month is okay, right?
yeah, effectively.
You got to slice it somewhere.
Okay.
So,
It all seems kind of random, but I know that's what you're just going through the legislation. Go ahead, Rick.
Married for 15 minutes in Las Vegas. That's considered a short marriage.
what's considered unconscionable, the Court of Appeal defined that in a case called Sarah and Sarah. And in fact, the court said that the threshold of unconscionability is exceptionally high. The jurisprudence is clear that it's clear that circumstances which are quote unquote unfair, harsh, or unjust alone do not meet the test. To cross the threshold, an equal division of net family properties in the circumstances must shock the conscience of the court. So
yeah, the judge was in shock. We had to stop the trial.
So that's basically the legal test of what
Judge had
unconscionability is.
All right,
So-
we want to save some time for, let's slide through our other slides here. And sorry, Rick, I just want to make sure everybody gets a chance to see these screenshots. Go ahead, Rick.
Yeah, so this is the net family property statement that we were referring to earlier. This basically sets out the value, the assets and their values for both parties, whether you're the applicant or the respondent, and you would just set them out in the columns and the values. It sets out the debts as well. That's later on in the family property statement. I don't know if we can. There's multiple pages in that.
Yeah,
but
let's through these slides, Steph.
This is a comparison of net family property statements. This is usually done when parties have different competing values for the overall assets and debts. It's a very useful tool in that it allows the parties to see how far apart they are. I personally like it better than the first one, because you can actually see exactly side-by-side comparison of what both parties are valuing the assets. Or
I agree. This is a great tool. You put all the data in, and it's usually 7-10 points where the numbers are off, and then you dig up the bank statement or figure out why there's a difference.
Yeah.
I need your bank statement from Canada Trust from 1975.
All right, Bill, listen, we want to save time for Q&A. Stop causing trouble.
You'd have to get that.
Limitation periods. What do we need to know? We'll give you 1 minute or less.
There is a 6-year limitation period to bring an equalization claim, 6 years from separation, or 2 years from the date of divorce is granted. But this period can often be extended if the claimant can show that there are apparent grounds for relief. In other words, there is an asset there. that they want to fight over, 2, the delay for making the claim has been done in good faith, and 3, no person will be substantially prejudiced. So the courts often extend that 6-year period.
All right, thank you for that, Bill. And it was 1 minute or less. So let's bring this train in the station. Our host, Stephanie's back. Welcome back, Steph.
Thank you so much. It's always a pleasure to hear all of the knowledge that you all can share. So before we dive into our Q&A, I just want to expand on what Russ mentioned earlier. So there will be a survey that pops up in your browser following the webinar. So please, if you have time, we welcome and appreciate any feedback that you have from today's session, so we can take it into consideration as we continue to grow our virtual event series. So one of those questions will be to share any ideas or any topics that you would like our team to discuss. So please, please, please let us know your ideas. And as a sign of our appreciation, we will be providing a complimentary e-copy of Russell's new book on mediation and family dispute resolution. So now I think it's a great time to move into our Q&A. So one that came in a financial settlement during a divorce, assets are devalued, mortgages overborrowed, rental income reduced to undermine the share of the weaker person. How does the court deal with these situations, and what precautions can be taken?
Bill?
Yeah, you're not allowed to do that. So what you can do is the things that Rick was talking about that shock the conscience of the court. One of those shocking things is if debts are incurred recklessly or in bad faith. Sounds like that applies here. So you could have an unequal division, or never mind debt. If you blow a bunch of money, they call it reckless depletion of money. If you do that, then again, the court can say, okay, I'm shocked and I'm going to make an unequal division. So that's how you'd fight that. And it does happen, but the law is designed to remedy it.
Amazing. And one more quick one. What is the best way to deal with post-separation adjustments? Is it best to deal with equalization first and add and deduct after? How would you approach it?
Rick, you want to take a crack at that one?
Yeah, usually you would calculate your equalization and then adjust it after the fact. You need to nail down the equalization payment first.
Yeah, we usually do a clean net family property statement, so we know what that number is. And then post-separation adjustments might be, property tax, mortgage, insurance, things of this nature are adjusted either in the favor or deducted from who's paying who. Great question though, Steph, thanks.
All right, lovely. And just to be mindful of everybody's time, that seems to be all the time we have for today. So I want to thank everyone and all of our panelists for taking the time to join us for today's presentation. We hope you found the content helpful, and keep an eye out for that follow-up email with links to helpful resources mentioned in today's presentation, and we will be sending that out tomorrow. So if you do have any questions about our virtual event series or any comments for our team, please feel free to reach out to Shannon at russellalexander.com or myself, Stephanie at russellalexander.com. We do host our virtual event series bi-weekly on Wednesdays at 12 p.m. on a variety of family law topics. Our next presentation will discuss the voice of the child on Wednesday, June 1st. So we'll be including a full list of our upcoming webinars in our follow-up email as well if you're interested to learn more. So thank you again for joining us. And again, that survey will be popping up in your browser just after the webinar ends.
And show notes with all the cases we discussed. I want to thank Rick and Bill for giving us an hour of their time today. Really, really insightful. Steph, thank you for hosting. And more importantly, I want to thank everybody who attended today. We had over 250 people register, so this is a record number for us. We hope to see you for the voice of the child in our future event series. So great work, Steph. I really appreciate everybody's time today.
Thank you so much.
Is this like the Saturday Night Live send off now?
Exactly.
That's great work, guys. Thank you so much. Everybody enjoy the rest of your afternoon and have a good day.
Thanks, you as well, Russ.
Are we doing a debrief?
Sure. We'll see you in the debrief.
All right.
Bye, everyone. Enjoy your days.